The Alaska Living Will. What is a living will? This is a document that allows an adult to state their wishes about what medical treatment or other end-of-life care they would or would not want if they become unable to speak for themselves. A person making a living will is called a principal or a declarant. A living will is often part of a larger document called an advanced directive for healthcare. Another part of an advanced directive usually allows a declarant to appoint another competent adult to make decisions related to their life support. This part can be called either healthcare proxy or power of attorney. While a healthcare proxy has the authority to make medical decisions, a power of attorney can also give the authority to make financial decisions. Why use a living will? By creating a living will, you will help your family decide on what should be done in difficult life situations when your health condition requires choosing life-sustaining treatment. The document might also help unnecessary medical care expenses. What should one write in the document? A living will should include the declarant's wishes regarding cardiopulmonary resuscitation, or CPR, mechanical respiration, tube feeding, dialysis, antibiotics, comfort care, and organ, tissue, or body donation. The name of the healthcare agent, if any. The principal's signature, location, and date. Can a living will be revoked? Yes, the document can lose its effect when it is physically destroyed, verbally revoked, replaced by a new living will, or canceled by a written revocation. Now, more about creating a living will in Alaska. In the state of Alaska, a living will is usually created in the form of an advanced healthcare directive, which includes a living will and healthcare proxy. It can be made by any person who is at least 18 years old and of sound mind. It should be signed and dated by the principal or by another person in the principal's presence. It also requires at least 2 witnesses of 18 years old or older. At least one of them should not be in any way connected with the principal. Alternatively, the document can be acknowledged by a notary. An advanced healthcare directive takes effect when a principal was diagnosed with a terminal illness or injury or is in a state of permanent unconsciousness, which makes them no longer able to understand and direct their medical treatment unless otherwise specified in the document. Note that in Alaska, you cannot use a living will to authorize mercy killing, assisted suicide, or euthanasia. At the same time, you could include a clause about an anatomical gift in your living will. A statutory living will form can be found in the Alaska Statutes, Title 13, Chapter 52. An adapted version of an Alaska living will is provided on, for example, the website of the Alaska Department of Health and Social Services.